We know what is admissible against each, and we can argue that specifically at the end.
We expect that we would be able to, and we're all working towards trying to keep those 5 days in August to do final submissions and put the case in the hands of the judge.
Day 37 of the Chris Barber and Tamara Lich trial just came to a conclusion. The biggest news of the day, the big takeaway, is that the two defense teams advised the judge that they will not be calling evidence at the conclusion of these proceedings. This is Robert Krajcik here in Ottawa, Ontario, reporting for Rebel News. Both Tamara Lich and Chris Barber are being charged with a series of crimes linked to their roles in involvement with the Freedom Convoy of 2022. You all remember this massive peaceful demonstration here in downtown Ottawa involving civil disobedience in broad opposition to what I have dubbed the COVID-19 enterprise, this massive apparatus of surveillance and control and coercion run by all levels of government, mandates, edicts, orders. A good segment of today's proceedings was dedicated towards this dispute between the prosecution and defense over the breadth or narrowness of an evidentiary submission from the Crown, specifically videos that the Crown wanted to introduce as evidentiary exhibits, selfie videos produced by the two defendants and posted to different social media platforms. In the case of Tamara Lich, to her Facebook profile. In the case of Chris Barber, to his TikTok profile. The defense teams were arguing that these videos submitted by the Crown lacked context, that they should have added to them other videos that were similar or related in order to provide a full comprehensive understanding, the complete breadth of the context of those statements. I'll give you a specific example. There was a video of Chris Barber out in Ottawa during the Freedom Convoy speaking about somebody burning some Canadian flags. And Diane Magus, the lead counsel for Chris Barber, showed other TikTok videos that were produced right in the same time, maybe an hour apart, wearing the same clothing, clearly on the same day, about the same issue. And she was saying that these videos must be included in the evidentiary submission from the Crown in order to understand, again, the full context of these statements. Now, let's consider that statements. In the context of an evolving, a dynamic, a protest like the Freedom Convoy, where everything is always in flux, it is hard to always determine where a statement begins and ends, especially in a situation where you've got people like Tamara Lich and Chris Barber regularly producing statements on the issue to their electronic digital profiles. If they're reporting or sharing information about this or that or the other, and things change 5 minutes later, 15 minutes later, 30 minutes later, they can add and amend and expand the original statements. So that's what was so interesting about this argument. The judge has yet to rule on that, but she will soon, we expect. Dear Rebel News audience, we depend on your contributions, your donations to help us stay afloat, to produce this in the field, original, on the ground journalism and reporting. So please help us continue. Visit tamaratrial.com. Help us out as you can and stay up to date with our ongoing coverage. The end of the day's proceedings were dedicated to a yet to be resolved dispute over the timing of a Carter application. The defense wants this to be resolved before final submissions. We were fortunate enough to speak with both Diane Magus and Lawrence Greenspan, defense attorneys for Chris Barber and Tamara Lich respectively, about their rationale for requesting that the Carter application be resolved, be adjudicated prior to the final submissions from both the defense teams and the Crown. Why? Because the determination from the judge over whether or not to accept the Crown's Carter application will play a role in shaping their final arguments. In other words, they want to know how to file their final submissions in accordance with how the judge plans to apply or not apply the Carter application. So what is a Carter application? Broadly, it is a request from the Crown to apply a framework of conspiracy to the defendants and the charges laid against them. If a Carter application is accepted in the context of this trial of Tamara Lich and Chris Barber, there is an interpretation that there was a conspiracy agreed to between the two defendants towards execution of an unlawful design, of a criminal act. And in order for the prosecution to persuade and convince the judge to apply this framework of conspiracy via the Carter application, it must prove beyond a reasonable doubt two things. Number one, that there actually was an agreement, a conspiracy towards execution of an unlawful design, of a criminal act or series of criminal acts, and that the defendants actually partook and executed in behaviors and actions in furtherance of that conspiratorial criminal endpoint. Now, if it is applied, if the judge does accept the Carter application, statements made by either defendant can be applied to the other. More specifically, we expect that to mean that statements made by Chris Barber, mostly in a digital format, which we've seen many exhibits of over the proceedings of this trial, will be then attributed to Tamara Lich. So that's yet to be determined, and we'll report on that as it unfolds.
One of two things I expect is going to happen tomorrow morning. Either Her Honor is going to make a ruling that the Carter application can be bifurcated or heard separately, and she'll call on the Crown either tomorrow or Monday to do that application. It's a Crown application. Or I suspect she may come back tomorrow and say, I'm being asked to do something which is unconventional, but very practical and efficient, and I want to make full reasons available to counsel. And so maybe she puts it over till Monday for that ruling.
Diane Magus is here.
Yes.
Defense counsel for Chris Barber. Can you tell us a bit about the presentation of videos that you showed, these TikTok videos that Chris Barber had produced, these selfie videos that you were providing, I guess, more context to? What was the purpose of showing those videos in challenge to the isolated videos presented by the Crown as an evidentiary submission?
The ones we did today, you mean?
Yeah.
The reason why there's an exception to, it's a bit complicated, but there's an exception to the hearsay rule that if a statement is put into evidence by the Crown, the whole of the statement has to be put in. And if a video is continued to a second video, then both videos have to be put in to be fair, so that the trier of fact can see both videos, or the full statement, if you will. So these particular 3 videos, we were saying they had other videos linked to it that we needed the judge to see, in particular with respect to the whole pictures vis-a-vis the one video that the Crown.
Can you elaborate for us laypersons? Bifurcation, we know what that means in English, but in the legal context, what is bifurcation in the context of hearing of this Carter application? I don't know what that means.
What that means is that we would hear the Carter application. Well, maybe go back. Traditionally, the Carter application is heard at the same time as final submissions. And that's usually the way it's done. And the Crown tried to point to some 17 cases where that's been the case without much success. And the reason that it's typically done that way is because of the Supreme Court of Canada decision in 1982 called Carter. So you have your submissions on the legal issue and your final submissions all at once going to the jury. Now, aside from the fact that the jury is not required to give any reasons for reaching their decision, who knows how they consider this legal argument? It's not it's certainly not a healthy practice, and Her Honor will hopefully depart from the practice, separate the Carter application from the trial itself, and so that we'll know when we stand up and make final submissions, we'll know what's in and what's out. And that was really the essence of our argument is, look, you're way better off. Determine the Carter application. Let's see what evidence is actually going in, what evidence is not going in, and then we'll make final submissions after that, as opposed to trying to guess what Her Honor is going to let in and what she's not going to let in, and making final submissions, in the event that you let this in, so-and-so will follow.
What is the prosecution seeking to do by pursuing its goal with the bifurcation?
The other way around.
To consolidate as opposed
Yes. So usually, if you have a jury trial, the issue of Carter is decided by the jury at the end of the trial. And everything's put at the same time because the jury has to come back with a verdict. And in deciding their facts, which facts they rely on, they have to decide the issue of Carter. So it's always done at the end because the jury doesn't come back with a decision and so on. When you have a judge alone trial, we're saying it would be much easier for the defense and the Crown to argue the final submission if we know what's admissible against one and the other. Because the Carter application is usually the rule is that whatever is said by one accused not admissible against the other accused. In this case, the Carter application makes it that the Crown is trying to have what's admissible against one accused, for example, Mr. Barber, is admissible against Ms. Leach. That argument, if we do it in advance of the final submission and the judge tells us, for example, that all of the evidence is admissible, then we know what we have to argue in terms of evidence at the end. If the judge tells us part of the evidence is admissible against both, then we also know. As opposed to the other way around, the Crown, the way they want to do it is that we have to argue in the alternative. Like if Your Honor finds that it's admissible, here's her submission. If Your Honor finds it's not admissible, here's her final submission. So we're trying to do it in 2 steps so that we know what is admissible against each and we can argue that specifically at the end.
So tell me if I got this correctly. I want to summarize this for the audience in terms of the purpose of making this decision ahead of final submissions. The judge's determination over the Carter application will shape the way you present your final submissions.
Absolutely.
Right. So it's about fairness to the defense to see how the judge is going to proceed with her adjudication in order to know how best to shape your final submissions to the best effect for your defense objectives, right?
To quote the Crown, absolutely.
Okay. And if you don't get her decision, let's say she was to do it at the end all at once, you've got to prepare for both sides. You've got to do almost twice the work, so to speak.
Yes. So and argue in the alternative, which is what we have to do when there's a jury. But if it's a judge alone, we're trying to make it easier for everybody so we know exactly what to argue at the end for everybody.
Lastly, as far as this, outstanding dates, nothing scheduled yet, right?
No, but I mean, August dates have been set aside. We elected this afternoon to call no evidence. And so those August dates are being held. And we expect that we would be able to, and we're all working towards trying to keep those 5 days in August to do final submissions and put the case in the hands of the judge.
One novel aspect of this trial, which occurred during today's proceedings, was Justice Heather Perkins McVeigh, the judge overseeing this trial, the trier of fact here, stating that this dispute over the comprehensiveness or narrowness of an evidentiary exhibit being submitted by the prosecution in the form of video selfies produced by Tamara Leach and published to her Facebook page is not something that people in the past who wrote the laws governing evidentiary submissions had contemplated. In other words, there is a technological novelty to this particular dispute, which is something unique to our times. Now, folks, remember, we cannot do this in the field journalism, this original reporting at Rebel News without your generous and appreciated financial support. So please visit tamaratrial.com, donate what you can, and stay up to date with our ongoing coverage.